Hello, good morning, everyone. Thank you very much for joining this very early morning session. I have the great pleasure to chair this wonderful panel. My name is Irene Kamara. I'm a researcher at the Tilburg Institute for Law, Technology and Society in the Netherlands, and also researcher at the Free University of Brussels. So I'm working on the topic of certification and standardization in relation to the right protection of personal data. The session today is going to be about the privacy shield. So moving from the safe harbor agreement to the privacy shield. This is quite a timely topic, I would say. We have now around 2,400 companies being self-certified to comply with the privacy shield. And back in September, there was the first annual review of the privacy shield. The European Commission, in its report on the outcome of the review that was published in October, concluded that the United States continues to ensure an adequate level of protection. But at the same time, the Commission came up with several recommendations for improvement. And those recommendations, they were not actually on minor issues at all. The appointment of the Ombudsman was mentioned, companies not declaring their compliance before they're actually really certified was also mentioned as a point of improvement. So you see, there were some important action points there as well. At the same time, the Working Party 29 published a report, and we're going to hear about this more from Laurent. And the Working Party in its report stressed that there were significant concerns in relation to the privacy shield, and those concerns should be addressed by both the European Commission and the US authorities. At the same time, we also have several pending cases, and we're going to hear more about this from one of our panelists. There are pending cases also in relation to the standard contractual clauses, so the alternative way to transfer data in case that there is no adequacy decision. And this is what we have heard so far in the conference as the Schrems 2 case. In the Cpdp launch event, we heard from the side of the Commission that there is this strategy, adequacy decision strategy, so there are ongoing negotiations with Japan, with Korea. So we see that there is the intention to, let's say, have more countries being declared as adequate, but at the same time we see that the privacy shield has all these several issues that are still pending. So it's very interesting to see how these two tensions can work actually together. So now I will introduce the panel. Our moderator is Joan Antokol from Park Legal. Joan is the founder and managing partner of Park Legal, which is a data protection law firm. And Joan in the US. Joan is the member of International Working Group on Data Protection in Telecommunications, and is also a Privacy by Design ambassador appointed by the former Ontario, Canada Privacy Commissioner. Joan will moderate the panel. Then we have Laurent Lim, who is our speaker from the EDPS. Laurent is a legal and policy officer with the Policy and Consultation Unit of the European Data Protection Supervisor. Before that, he worked initially in the private sector and then for the French Data Protection Authority, the CNIL. And Laurent has very valuable experience to share with us. He recently participated in the first EU-US Privacy Shield joint review exercise in Washington as a member of the team of the European Data Protection Representatives, and he's going to share more on that. Then we have William Malcolm from Google. William works with Google's product and engineering teams globally on a range of product design and privacy compliance issues. And prior to joining Google in 2011, he was leading member of the Pins & Mason's Privacy and Information Law practice. Our next speaker is Carol Evrard from Stibbe. Carol works at Stibbe, which is a Benelux law firm in the technology, media and telecommunications field. She studied in Liège and Cambridge, and Carol will update us on the case law and current open issues regarding the shield and data transfers. And last but not least, Nora Lidsson, yeah, thank you, is a director and lecturer in law of Information Law and Policy Center at the Institute of Advanced Legal Studies at the University of London. Her research interests and publications concern governance, human rights, and technology. And Nora will reflect on broader issues and the impact of a privacy shield, and discuss a very, very hot topic, the cross-border transfers in the post-Brexit era. So now I will pass over to Joan. I'm looking forward to a very fruitful discussion.
Thank you, Irene. Good morning, everyone, and thanks for joining. I have a lot of experience safe harboring companies, certifying companies to the Safe Harbor framework, and have also started certifying companies to the Privacy Shield framework. I've maybe certified 5 or 6 so far and have a number of others in the works. So feel free to ask questions. This is one of those rare opportunities where you can get free legal advice. So the Safe Harbor framework, as most of you know, was invalidated by the European Court of Justice on October 6, 2015. And it was invalidated for a number of reasons, including the fact that individuals were not given a right of recourse against mismanagement of their data, including by the US government, and they didn't feel that there was proper oversight for the program, so the adequacy decision was withdrawn. The Privacy Shield framework went into effect on August 1st of 2016. So not such a long time ago, and as Irene mentioned, there are about 2,500, I think closer to 2,700 companies that have already certified to the Privacy Shield framework. So by comparison, this is about 50% of all the companies that had ever certified to the Safe Harbor framework. There are about 5,500 overall, and that framework was in place for 16 years. So quite a few have already certified, and a number of others are doing so right now. The programs have a lot of similarities. There are 7 principles for both programs. There were 15 frequently asked questions under the Safe Harbor framework, and they've been turned into supplemental principles with an additional one added, so 16 supplemental principles. The 16th relates to law enforcement access. The principles have changed somewhat. Some of the terminology has changed, the names of the principles, but also the expectations have changed. So there are more rights for individuals under the Privacy Shield framework and more oversight to address the gaps that existed under the Safe Harbor framework. And there are some other aspects to the program that weren't included in the Safe Harbor program. For instance, there's a right of arbitration for individuals who feel that their grievances have not been adequately addressed by the company. There's also more oversight by the Department of Commerce, although it's the same practice of submitting a form to certify. The Department of Commerce representatives are looking at the forms in more detail. There's more scrutiny overall. You also have to post a Privacy Shield notice on your website now, along with the description in your privacy notice, in your website privacy statement, which was not the case in the past. And until now, until the recent meeting that took place between the European government and the US government in September, you were required to post those materials up front as part of your certification. And of course that created a gap because you were holding yourself out as certified when in fact you weren't. So that part of the program has been changed, and some changes to the arbitration. You have to pay the fee up front as well. There's also a requirement now for organizations to maintain good documentation for the Privacy Shield framework. Of course, this was always expected. and something that I found in my experience did not always take place with companies under the Safe Harbor framework. Sometimes I'd be called in by clients to help with their annual reaffirmation, and somebody else had prepared their certification or they'd done it in-house. And I didn't always find good documentation. And now the regulators can request that documentation to see how you went about certifying for the program. So a higher obligation and more emphasis on the commitment to the principles under the Privacy Shield framework to protect individuals. There will also be more enforcement under the Privacy Shield framework. We've already seen the first group of 3 companies that was subject to enforcement on September 8th of last year, 2017. 3 organizations that held themselves out as Privacy Shield certified when in fact they had never submitted any documentation or taken any of the steps to certify and make the necessary commitments to that framework. By contrast, under the Safe Harbor program, there were 39 enforcements over the period of 16 years that program was in effect, and the first one didn't take place until 2009, 9 years after the program was first put into effect. There are more fees under the Privacy Shield framework to support the additional enforcement. Under the Safe Harbor framework, it was $200 for any company, regardless of size, to certify, and $100 per year. And now there's a scaled approach based upon the revenue of organizations to certify, and organizations over $5 billion, for instance, have to pay, I think it's $3,450 per year, and then a separate fee if you also want to certify for the Swiss-US framework. So that's an annual fee that you have to pay with your reaffirmation, and then there's also an arbitration fee that the Department of Commerce has said that it's a one-time fee for arbitration, but they can come back and collect again if they run out of money, and that's $10,000. So one other unique component of the Privacy Shield is that if you decide to no longer participate, you still have to reaffirm every year, or at least pay the fees, and for as long as you retain the data. So this is an additional protection for individuals, that you still have to commit to the program, even if you decide to no longer participate or withdraw from the program. And that was not the case under the Safe Harbor. And there's also a debarment list. So if you don't uphold your commitments to the program, you can be permanently debarred from the program. So it's interesting times in the world of data protection, and it will be interesting to see how all of this falls into place, particularly under the GDPR. So for those of you who aren't familiar with the program, these are the principles: notice, choice or consent, accountability for onward transfer. The Safe Harbor program was simply onward transfer, security, data integrity and purpose limitation. Oh, I'm sorry, there you go, sorry about that. Data integrity and purpose limitation used to just be data integrity, access, and then recourse, enforcement, and liability, which used to be enforcement only. Okay. So we'll be talking more about the GDPR and how it will align with the Privacy Shield framework and the different obligations that will apply to organizations. And then we'll also be talking about other discussion topics, such as the potential invalidation of the Privacy Shield framework, since it's already being challenged, as well as the impact of Brexit. And I'll now turn the presentation over to Laurent to continue.
Okay, thank you. Good morning, everyone. I think I will move to here because it will be easier for me. Can you hear me if I speak here? Okay, so I'm working with the European Data Protection Supervisor's Office, So we have simply a disclaimer here, just saying that the views that I am going to express here are more personal views, and shall not prejudice the positions and opinions of EDPS in the future cases. So where did the EU-US Privacy Shield come from? You all know it come from the safe harbor in 2000 by an adequacy decision by the Commission, which gave actually to the United States the first adequacy decision. So it was the first country to obtain adequacy. And at the time already, the group of European data protection authorities were quite concerned about this topic. It was that's why you find a lot of opinions already at the time. So it was a topic already in 2000 that occupied European data protection authorities a lot. Then you had some criticism also from the private sector with the Galaxia report, 2008, and the Snowden revelations, of course, 2013, which led to the case, Schrems case, by the Court of Justice and the annulment of the safe harbor. So I'm not going to go too much into details in the slides of what it is. It has just been explained. It's a package of principles. Maybe it's interesting to note that we are talking about written commitments of the US administration. So, based on which the European Commission is taking its decision of adequacy. So it's a self-certification program. So it's pretty much like the safe harbor. It has been said it's very similar. For some parts, we could also even say it's a copy-paste. For example, the FAQs of the safe harbor, former FAQs, have been simply copy-paste into additional principles. So we've been, maybe we will talk a little bit later about the list, the Privacy Shield list. It's interesting to know also that the scope of the Privacy Shield does not cover all activity sectors in the US because only companies which are under the jurisdiction of the Federal Trade Commission, the FTC, can apply for certification, which means that, for example, financial institutions or telecommunications providers are not into the scope of the Privacy Shield. But there might be a gray area here. For example, if some banks are transferring data for HR purposes, there might be the US authorities might consider that they might apply for that particular processing under the Privacy Shield. So we have renewed commitments. It has been also explained already. We have new mechanisms of redress to the benefit of EU citizens, and notably the EU Privacy Shield Ombudsperson, which I will talk a little bit later. New arbitration mechanism. So how does it work? Pretty much like it was working under the safe harbor. You have a publicly available online list. So once the self-certified company are certified, then they are on this list. You can check this list. You can check the certification. You can check the status of the certification, because valid or not, it's valid for 1 year. US companies have to recertify, and you will find a number of details into these certifications, the type of data that is covered, and maybe there is also here interesting to know that there is small differences into interpretation of what is HR data, human resources data, which should be covered by certification. US authorities basically see HR data only in the case where you have a US mother company which is transferring back to the US data from its own employees. That would qualify for US authority as HR data, but not in the case of of a processor or service provider in the field of human resources, which is processing data from clients from the EU. In that case, US authorities will consider that it is not an HR data transfer. So this is, we are discussing with I will explain a little bit later. We're discussing with our US colleagues about this. You will find also a link to privacy policies, contact details of the DPOs, and the dispute, the alternative dispute resolution mechanism that has been chosen by the US company. Normally, if the transfer is about HR data, the US company has no choice. The dispute resolution mechanism has to be the EU panel of DPAs. But then the choice comes when, for other US companies, they can still decide to opt to have this EU panel of DPAs as a dispute resolution mechanism. Figures have already been given. Maybe here it's interesting to know that 50% of Privacy Shield certified companies are SMEs. And we're still far from the 4,000 US companies certified under the safe harbor. So why is that? The US administration had some backlog with initially, of course, with the first implementation when it began last year of the Privacy Shield. So it might be a reason also because possibly after the annulment of the safe harbor, some US companies decided to switch to other mechanisms such as standard contractual clauses. And they might not want to go back to certification, taking into account the fact that we have some legal uncertainty about this Privacy Shield, because, as I said, it's based on commitments of US administration on the surveillance part. It also relies heavily on what's called a Presidential Policy Directive, PPD 28. And there was a lot of questions of whether this was going to be maintained or not by the new administration. It has been the case, but still, we would like to see something more into horizontal US law rather than relying on commitments by administration. There is also a question whether adaptation of this framework to the GDPR might become necessary as of May 2018. And we'll talk a little bit also about the influence of the new administration in the US about the functioning and the whole situation of the framework. And we have challenges into courts. So these are the reasons why one could think that there is some legal uncertainty. So in September 2017, we had the first annual joint review. The Commission published its report. I have summarized here the basic, the 10 recommendations that the Commission put forward. And I will go more into detail into the report of the WP29 on the joint review. So the goal was to check if the concerns expressed in 2016 were resolved, and see whether the safeguards were workable and effective. So on commercial aspects, there has been progress in comparison with safe harbor. For example, the Department of Commerce has set up a team of 10 people to deal with the certifications, the recertifications process. We could talk maybe later during the questions about the false claims. There has been 3 cases sanctioned by the FTC already under the Privacy Shield, but still we have important issues which remain. I spoke about the human resources. We have also not much on the principle of automated decisions making and profiling. And some issues that we already identified in 2016 are still unresolved. On the government access side, here also US authorities clearly made some real efforts towards more transparency, but still we have some concerns about further evidence that the programs have been changed in the way they operate and the way they target information. There was also this debate about reauthorization of the Foreign Intelligence Surveillance Act, FISA, Section 702, which is the basis for surveillance of foreign countries, and it was initially due to sunset on 31st of December last year. Then it was until 19th of January, but then it has just been last week reauthorized for 6 years. And we have also the problem with the appointments of important institutions there, as of the ombudsperson and the P Club. This is in the conclusion of our report, where we call the European Commission and the US authorities to restart the discussion immediately and to set up an action plan to come up with solutions as regards these concerns. But what is prioritized maybe is the nomination of the ombudsperson and of the P Club, because right now the P Club is under quorum and cannot function, so it means they cannot decide to launch new investigative programs. So I'll stop here, and I think we will have some time for questions. Thank you.
Thanks very much, Laurent. And now we will hear from William from Google.
Great. Good morning, everyone. Thanks for coming out so early. I hope you've had plenty of coffee from the vendor outside. Thanks for that overview. That gives us a great jumping on point. I'm going to talk probably just for 5 minutes or so, give you an overview of how Google's approached these challenges. I want to leave plenty of time for discussion and questions at the end. Probably useful to start with an overview of how Google approaches international transfers compliance generally, the mechanisms we rely upon, before we talk about our specific application of the shield. And I'm the technician in the room. I'm the person who actually has to implement the shield. So I'm going to talk a little bit more about the process of doing it, my experience of doing it, and my team's experience of doing it. What I would say from the outset is that we have 2 primary methods of ensuring adequacy at Google that we rely upon. One is the shield, which we'll talk about. The other is the model contractual clauses, which we make available as an option for customers of our cloud products, like Google Cloud Platform or Google Apps. And so, customers signing up for these products have a choice. They can rely upon our certification under the shield, or that they can choose to enter into the model contractual clauses. We're one of very few companies that has submitted our model contractual clauses to the working party for approval under Working Party Opinion 226. Not sure how that's going to translate to the new GDPR world. We will see. But our clauses that have therefore been reviewed by all members of the Article 29 working party who adhere to the Working Party Opinion 226 process. And what that means as a practical matter is that clearing for companies that choose to sign those clauses, liaison with the DPA or prior approval requirements in local jurisdictions are made much easier. So in terms of our adoption of the shield, we adopted the shield in September 2016. We were one of the very first companies to do so. Not the first. We felt it was really important to take our time, make sure we were getting it absolutely right, but we were one of the very first companies to adopt it. And I'd ask you to look at the scope of our certification. Again, we're one of very few companies to have certified for all products. Many hold certifications which are narrower, but we have certified for all products, which I think is our a sign of our faith in the Shield, our investment in it, and the level of resources that we've put in place internally to ensure that we're meeting the substantive requirements of EU data protection law. We're also one of only 2 companies, as far as I understand it, to have specifically signed up for the jurisdiction of EU data protection authorities as part of the complaint handling process. So we specifically opted for that route under the Shield, and we did that very deliberately. We have strong, robust internal processes, and we are happy to be subject to the scrutiny of Europe's data protection authorities in the way in which we apply them. So let me talk a little bit more now about 2 things. The process of how we go about our internal certification and some of the changes we made from Safe Harbour to Shield. Perhaps one of the first things to say is that the changes from Safe Harbour to Privacy Shield are not cosmetic. They are real. And if you're a compliance officer or someone responsible for within your organisation for implementing them, don't view it as a small change. It shouldn't be. We put a much higher level of resource into our Privacy Shield certifications. We always had, I think, a robust Safe Harbour process, but we really doubled down on that under the Shield. So what the process at Google takes approximately 4 months from end to end, which often means we're no sooner done than we're starting the process again for the following certification. We have a range of products at Google, and so it's a fairly time-consuming process to walk through to make sure that we're properly applying, each of the principles to the products. We also use it as an opportunity to ensure that program documentation under our core privacy program is properly completed. So at Google, we have something called a privacy design document, which is a document that captures data within the engineering life cycle of a product, system, or project. And a key part of the internal thing that we do is make sure that those documents are updated. So product lawyers and technical leads, as part of the certification process, have to sit down and make sure that those core program documents, which capture how data is processed within products, are up to date. And so in a way, the Privacy Shield process sits alongside the core program and complements it, but it also provides us another moment, another point in the year where we can check that some of our core program requirements are being met. And actually, Google is subject to EU privacy law directly. In addition, we will be subject to the GDPR, and we need to meet the privacy impact assessment processes under GDPR. And so one of the things that we're doing now is making sure that those 2 processes are properly aligned, because one wants a thorough review. The certifying official needs to be confident in the standards that the products meet, but we also have to ensure that the 2 processes fit together and make sense to the business, and are properly integrated, and that's one of the things that we're kind of working on now. In terms of some of the specific changes, we updated our privacy policies. So a full list of the covered privacy policies is linked to from our certification. These updates give notice of our participation in the Shield, details of how to lodge a complaint, which I'll talk more about in a second, our commitment to cooperate with authorities, the fact that Google is subject to the investigatory and enforcement powers of the US Federal Trade Commission, and the possibility for individuals to seek arbitration in certain circumstances, or continued liability for transfers, etc. One of the big changes was our relationship with third parties. So as a consequence of the changes, we had to put new contracts in place with over 300 vendors. That is not an easy task, and those who are looking at the enhanced contractual requirements under GDPR, both on the vendor and customer side, know that the level of resource and commitment and effort that is required. The Privacy Shield process had to be done quickly, so it was a huge effort from our teams to ensure that those vendor contracts were properly updated and that the additional standards which our kind of speakers referred to were properly put in place. Complaint handling. We've heard about the formal complaints, but I want to just give you a sense of again, to show you that this is a real living framework. We've kind of established a new dedicated mechanism to lodge complaints or inquiries regarding our Privacy Shield certification. So there's a Privacy Shield web inquiry form. I'm at time, so I've got 2 minutes, that's good. And for users based in the European Union. And the form is supported by a dedicated team who respond to those queries. So in 2017, again, just in the interest of transparency, we had 179 inquiries, averaging 3.4 a week, all of which we responded to quickly. So it's not just the enforcement you hear about, there are actually inquiries that are made of companies and that are being dealt with in a practical way and that never need to be dealt with by one of the authorities. So that again shows the effectiveness. The last point, I'm at time, we can save more for questions, but ultimately the last point I'd raise is that we're also sensitive to the national security and law enforcement concerns. We continue to publish, I think, world-class transparency data on those areas, as well as implementing, I think, a best-in-class compliance effort. So I'll save more for questions and pass over to my fellow panelists.
Great. Thank you very much, William. And now we will hear from Carol.
Can you put my presentation?
Yes, yes.
With my computer?
Yeah, if you want to look at this.
Oh, it's not. I have it.
Yeah, it's next.
Okay. Good morning, everyone. So I'm going to talk a bit more about the legal actions that have been brought, firstly against the Safe Harbor, and then now against the Privacy Shield. So I'm not going to spend too much time on the case against the Safe Harbor, but you have the references there. So it's actually a guy called Maximilian Schrems who could have the Irish courts ask a question to the Court of Justice, by the way, as part of his PhD. And at the end, the Court of Justice decided that the adequacy decision of the Safe Harbor should be declared invalid. So I'm not going to talk too much about this, but what is important to know is that the Privacy Shield is currently also being challenged. And it has been challenged twice. So firstly, by a group called Digital Rights Ireland. And the difference here is that we don't stand before the Court of Justice, but before the General Court. Why? Because it's not a preliminary question, but it's a direct action for an annulment of the adequacy decision. This case has recently been declared inadmissible by the courts. Why? Because for direct actions, you really need to demonstrate that you have an interest in the outcome of the case. And in that case, the court decided that Digital Rights Ireland has no interest in the annulment of the Privacy Shield. So that's it for that case. But a second case has been also brought before the courts by La Quadrature du Net, which is a French privacy activist group. It's also before the General Court. It's also an action for annulment. And they claim that the adequacy decision of the Privacy Shield violates some articles of the Charter, so Article 7, 8, and 47, which pertain to privacy, of course. They put forth 4 pleas in law. I'm not going to describe them too much, but in summary, their first criticism is about the generalized nature of the collections of data by the US government. Basically, they say that US intelligence services do operate bulk collection of data, which is not allowed under the main principles of the GDPR or the directive. The second criticism is about the fact that they claim that there is no limitation to the future use of the data. So when the data is being transferred, there should be also restrictions to the way the data can be subsequently used by the authorities. The third criticism is the lack of effective remedy. So especially for European citizens, it's very hard to contest the processing of their personal data by US companies. Mainly because the US, as many member states, do have standards loci obligations, which oblige the data subject to demonstrate that they are affected by the processing. So sometimes it's very hard for European citizens to effectively have an effective remedy before the US courts. And the fourth criticism is about the lack of independent monitoring. So the Court of Justice in the Schrems case has said that there must be a prior administrative or judicial or any kind of control when data is being collected. So, and according to the Quadrature du Net, it's not the case yet. It will be interesting to see what the court will say about the admissibility of this case. My point of view is that the big difference between Digital Rights Ireland and La Quadrature du Net is that La Quadrature du Net is really an association. So as an association, it can act on behalf of its members. So we'll see, but in my view, the case probably will be declared admissible. The second question is the impact of the first annual joint review. Because Laurent explained to you what the big challenges of this review were, but at the end, the review was also preceded by a few days of officials from the Commission and from the DPAs being in the US, discussing with them, and at the end, the conclusion of the report is still that the US ensures an adequate level of protection. So what will be the impact of this conclusion, and what influence would it play on the Court of Luxembourg? And what are the counter-arguments? It's not an exhaustive list, of course, but these points, in my opinion, are very interesting, because the first one is the fact that Article 25 of the Directive, so the one which allows the Commission to take adequacy decisions, doesn't require third countries to have an identical level of protection and to have identical means for protecting privacy, but only adequate means. So Article 25 also says that you must take into account all the circumstances surrounding the case, and also the country of origin and of final destination. So it's about comparing US law and the law of the member states. So basically, you can't impose more on the US than what is currently being done within Europe, which is a sensitive point, of course, because the member states won't really agree to say what they do in terms of surveillance. The third argument is related to the force. It's the fact that after Schrems, the US is really engaged for 2 years in a broad review of its legislations. And for instance, the US Freedom Act has been adopted in 2015. There's been a new ombudsperson mechanism put in place. We can also cite the Principles of Intelligence Transparency adopted by the Office of the Director of National Intelligence. So all of these new developments really show that the US have made an effort since Schrems. So let's keep an eye on what's going to be decided in Luxembourg, because the future of the Privacy Shield will be decided there in the coming months. So I leave now the floor to Nora.
Thanks very much, Carol. I excuse me, I'm in that unenviable position at the end of a really impressive panel but nevertheless, I will raise some points about what lessons that the Privacy Shield have brought forward for other third countries, or other countries that may soon be third countries. I will just break this down in terms of talking about lessons from the pre-legislative stage, evaluation and review, and then going forward, recommendations for third states, and then just a final point about developments concerning Brexit at the end. So in terms of how the Privacy Shield has developed, in terms of drafting and consultation with the EU institutions, the process was quite lengthy. We're talking about 2 years, and it will likely be the same for other third countries. Notably, the US has a special status in terms of its economic power, but at the same time, it's still going to be quite a lengthy process for most third states to enter into when they go into these negotiations with EU institutions, not just because of Schrems, but also of the precedent now set by the Privacy Shield. And in terms of the standards that will have to be followed there by third countries, Schrems obviously sets down a precedent, as does the Privacy Shield, and so do the many provisions of the GDPR. In terms of evaluation and review, we know that Schrems has set down a new threshold in terms of what we already had established in the 1995 Directive, which is the threshold of adequacy decisions meeting essentially equivalent standards. So in terms of compliance and monitoring, not just on the side of the national institutions like the Department of Commerce, for example, and the FTC within the US, but also within the EU institutions themselves, such as the European Commission and the European Data Protection Board once it's appointed. These reviews, these evaluations, as we've seen from the first annual review, are going to be very detailed, very prescriptive. The thresholds are going to continue, as we heard from Laurent today, to be very demanding, not just in terms of the substantive provisions, like the principles and safeguards that these adequacy decisions have within, but also in terms of the procedural frameworks that national countries and their institutions put in place to monitor and enforce and to keep under review these adequacy decisions. And also in terms of the thresholds, as we've seen from the annual review and in the points that Laurent brought up as well, in terms of what is essentially equivalent, well, these very much mean you have to be in line with not just EU data protection legislative standards, but also in terms of the approach of how monitoring and compliance is undertaken here by data protection authorities and the European Data Protection Supervisor. So in terms of going forward and recommendations, for all relevant third countries, for the 11 who will have to now update their adequacy decisions in light of the GDPR and Schrems, and also the Privacy Shield. And again, for those countries making up their mind to confirm whether they're going to be a third country or not in the next couple of years, they should give notable consideration as early as possible to be in consultation with all of the relevant data protection authorities, and particularly the European Data Protection Board once it's set up in May. And they should also take much advantage of Article 50 of the GDPR in terms of international cooperation. And this is the provision of documentation, advice, and support from these EU institutions when they're developing or reviewing their adequacy decisions. Finally, then, in terms of talking about the EU institutions, and of course there's considerable focus on the European Commission because of the leading role it will have in reviewing adequacy decisions. There is one institution that we all can't forget, and that is the Court of Justice of the European Union, particularly the Grand Chamber, because as of 2014, there was a new sheriff in town after the Snowden revelations, but also while we have considerable focus on the Snowden revelations and the influence that they've had in the shift in policy making, not just within the EU, but also within the US as well. Carol mentioned some of the legislative provisions. You also had a shift because as of 2009, the EU finally had its Bill of Rights, the EU Charter of Fundamental Rights. And in particular, you then had, under the EU Bill of Rights, you had two fundamental rights, well, as we do, to data privacy, Article 7, which is to respect private life, but then we also have a completely autonomous right with no equivalence under other human rights instruments, and that is the right to data protection under Article 8. And the Court of Justice, as we saw in Schrems and in other consistent case law, has very much given a very expansive scope to the safeguards underneath this right. And we see it in particular in Schrems with regard to the requirement, as Carol just mentioned, of having prior authorization and review by an independent body, not necessarily judicial, but preferably judicial, but nevertheless independent. And that is going to be one of the key issues in the upcoming proceedings, and it will be interesting to see whether the Privacy Shield indeed survives that. So finally, in terms of finishing up, because I think I'm running a bit low on my time here, let's talk about the giant elephant in the room with the Union Jack, which is Brexit. So currently, in terms of adequacy decisions, the legal status of the UK, from the perspective of UK institutions, is of yet uncertain. In certain documentations, it's taking the approach that it will be a third country, but officially speaking, nothing has been confirmed yet. However, from the perspective of the EU institutions within the field of EU data protection law, a statement was made recently in the past couple of months that the UK will indeed be treated as a third country for the purposes of data protection legislation from March 2019. So, given this focus, it seems advisable that the relevant institutions within the EU would now start taking steps to take advantage of all of those provisions under Article 50 of the GDPR in terms of preparing for what adequacy decision they're going to put in place. Also, in terms of the fact that we don't know for certain if the UK will indeed be a third country, there are other options being explored. For example, perhaps they will decide to become a member of the EEA, the European Economic Area, like Norway, for example. And in that respect, the fact that the UK is currently revising its data protection law in line with many other member states in the EU right now, if they have implemented the GDPR by the time Brexit takes place, there is currently an understanding within the UK public institutions that this will be of great assistance in terms of being one of the factors in which they will be assessed in terms of adequacy decisions in future. Another key factor as well that a lot of reliance is being placed on in terms of being assessed for adequacy decisions in future is the fact that the UK is a contracting state to the Council of Europe's Convention on the Protection of the Processing of Automatic Information, Convention 108. Now, this is an instrument from 1981. It has since been revised. However, this revised version has not been ratified and confirmed by one of the contracting states, Russia. That is still pending. Nevertheless, there is an emphasis in the UK that if these standards from the revised draft version are adopted, that this will also be quite significant in the assessment of an adequacy decision in future. However, I would urge caution in this respect, because as we know from the Privacy Shield and also from the quite detailed provisions of the GDPR, there are many, many factors that will be taken into assessment by the European Commission when they are determining the validity of an adequacy decision based on the legal system of the third country in question or otherwise. And in particular, a real fly in the ointment for the United Kingdom is the judgment of Watson, the Grand Chamber judgment that put forward a number of issues regarding law enforcement issues and the access or mass indiscriminate surveillance by the secret intelligence authorities. Now, the UK has implemented a number of those provisions, but at the same time, there are some questions regarding some of the mass surveillance bulk programs that are still outstanding, and this is yet another factor that the UK government is going to have to deal with in the next 2 years. Thank you.
I'd like to thank everyone on the panel for their excellent contributions. And before we take questions from the floor, I'd like to let you know that we have a very special honored guest in the room who's often referred to as the father of data protection based upon all of the work that he's done. Peter Shaw, the former federal commissioner of Germany, and also the former chair of the Article 29 Working Party. We're happy to turn the floor over to you, Peter, to make a few comments on the panel, and then we will, the panel's discussion, and then we're happy to take questions from the other attendees.
surprising. I'm not a part of it.
I feel like we should give you a standing ovation.
Well, I am still active in this field. Well, thank you very much for this opportunity. Well, this is a very good timing because the European Court of Justice has announced a decision on the Schrems II case today. Yeah, that today or tomorrow. I have two different messages, but we will know more, perhaps in a few within a few hours. But one word was used. We have to explain, perhaps. Essentially, the same level of data protection, safeguards. To protect the data in the third country, and that means that all circumstances which are relevant have to be taken into account. And one of these circumstances are the activities of intelligence community, NSA, CIA, and so on. And when the UK is not anymore member state of the European Union, even the activities of the intelligence services will be assessed, and they have to meet this criteria. Today we have the strange situation that under the EU law, the activities of intelligence do not fall under the European legislation. So the primary law excludes explicitly national security, and therefore the intelligence services of Germany, UK, France may act in the same way as the NSA does, but without any effects of adequacy inside the Union. So I would say we need more clarity about the activities of our secret services in the Union. Second is, if the GDPR comes into force, the adequacy decisions remain valid. They will not be invalidated. But the question is, what will be, in the middle term, the effect of the GDPR on the adequacy decisions? As Mr. Lim has pointed out, we will have such effects, of course, because the new GDPR provides the citizens with new instruments which are not foreseen in the adequacy decisions and in the safe harbor regimes like data portability. So a lot of questions, but at the end I would say we need such agreements because these systems help our societies which have to follow the rule of law to come together. And it's not only a question of economy. China is a big player in this field, but we all know that civil rights, rule of law are not really implemented there. They are not valid. So we need more common understanding how to protect the people against the abuse of data, especially by public authorities. So we have to focus more on this.
Well, thank you very much, Peter, and it's such a pleasure to have you here amongst the guests today. So yeah, I think the burning question for all of us is the GDPR and the impact on the Privacy Shield. Obviously, the GDPR was already contemplated when the Privacy Shield was approved, so the assumption is that the regulators already took that into account in determining adequacy for the program. But in practice, how will it actually work? We don't really have any guidance at this point. For instance, if a company certifies to the Privacy Shield and does so appropriately with the right reviews and documentation and so forth, and then they hire third-party subcontractors and use the onward transfer principle and so forth, what reviews have to take place in terms of the subcontractors' GDPR compliance? For instance, do you need to make an assessment as to whether they have privacy by design in place, or data protection impact assessments? And what do you need to put into your agreements with those third parties? Maybe Laurent can give us some guidance on that question, and then we will take questions from the audience.
Okay, for me, the Privacy Shield is an adequacy decision mechanism, which basically has the effect that we consider, or the European Commission considers, that the US company in the US, which is certified, is the same or equivalent as an EU company. So basically we rely on this adequacy mechanism, which is the highest available tool for transfers. And then we have to rely on the principles which are inside the Privacy Shield as regards onward transfers, for example. So which means that you have to make sure that the subcontractor is either also self-certified with the Privacy Shield, and if it or established in another adequate country, and if not, then you have to resolve by contractual solution. That's what was explained here. So that's how I see the things. But yes, then you have this rule in the GDPR saying that when you are targeting directly EU citizens, then and if you are a US company, then GDPR will be applicable to you, and you will have to comply with the GDPR. But if you are US Privacy Shield certified, normally you do not have to do any other thing than this certification process. But maybe you will have other views.
I know we're very keen to get to questions, but one very quick remark on that, which is that I'm talking directly about Google. We are subject to EU data protection law today. We will be subject to the GDPR directly. So to Peter's comments about privacy by design and portability and the like, we are directly subject to these requirements, and authorities can enforce them directly against us. So in a sense, and of course the GDPR will open up the number of foreign controllers who are subject to the law, either through application of the establishment tests under Weltimo and other cases, or under the targeting test. So you'll have a whole host of companies that are currently certified under the Shield that are perhaps directly subject to EU data protection law that weren't before. And so one thing I would emphasize is that the Shield is not the only accountability mechanism in that respect. It is open to EU regulators to directly enforce the GDPR and its terms.
Okay, we're happy to take questions now. This bright light shining here. Step forward and introduce yourself, and we have this bright light here.
Yes, good morning. My name is Nina Popolova. I'm from the University of Oslo. My question is more directed to Laurent, but feel free to also address this. I wonder, it's been a year now, so we have the review, and you've been in Washington. So I wonder, what's your opinion? how long will it take to fill in the empty positions that are needed, and especially in the context that we have the section 702 renewed, and so these mechanisms should be in place, and well, maybe if the French NGO case still will be declared inadmissible, there might be still a chance that a natural person will bring action before the actual positions will be filled, and challenge these these vacancies and these kind of flaws of that are still not put in place for the framework to fully work.
Thank you.
Okay, so thank you for the question. Yes, it's essentially political, this issue of nominating people, appointing people into the ombudsperson. There is someone, but currently acting only. And also for the P Club, we met in Washington with the sole member remaining of the P Club, and it was very good to meet with her. But she explained that an announcement has been made for a nomination of the chairman of the P Club, but it has not been confirmed by the Senate. We had the chance in the margin of this conference to meet with Peter Swire, who was advisor on privacy for President Obama, and he's following these things. And basically, he told us that there are discussions between the Congress, because you need to have 3 Democrats, 3 Republicans, but still no decision comes up, and this is a real concern for us, because the P Club has done a very, very good job with publishing reports and launching investigative actions into they're looking really into how US intelligence services work. But they need a quorum to be able to decide and to vote for launching new investigative programs, which is not the case right now. That's why we are really calling for a swift nomination in the P Club. But so far.
Comment very quickly on that. Excuse me. I mean, in the annual review report by the European Data Protection Supervisor and the Article 29 Working Party, there is a ticking clock right now in terms of when that needs to be met, which is the time for the second annual review of this year. So there seem to be 2 different timelines, that of the US and one of the enforcement and monitoring bodies here, which is May of this year.
Okay. Question in the back.
Thanks very much for your insights. My question is rather brief, and actually it relates to the scope of the Privacy Shield. So it was mentioned that financial services firms as well as telecoms are excluded. So I wonder if there is some other mechanism that applies to such firms, or whether they face more restrictions in terms of being able of transferring data between the US and Europe.
That's a great question. The reason for the limitation is that the program is enforced by the Federal Trade Commission, and the Federal Trade Commission only has jurisdiction over certain entities. They don't have jurisdiction over financial institutions and nonprofits. They're not able to participate in the program. There's been a question for many years as to whether there could be a similar type of program, or whether those organizations could submit to the FTC's jurisdiction voluntarily in order to participate in the program. So it would certainly be a good thing for financial organizations and others in the US to be able to participate. Laurent, do you have anything to add on that topic?
Yeah, there might be a gray area in some, as I mentioned, in some cases, because the FTC said that they would consider, or they would allow some financial institutions to apply for Privacy Shield. For example, the example I took, when they are processing and transferring data for human resources purposes only. So they would still consider that would fall under the jurisdiction. So you really have to check with the FTC, I will have to say. There was also, during the joint review, discussion about airlines, because there would be also the issue of whether the Federal Transportation Authority is competent over airlines or not for the data processing. It turns out that the FTC will be competent, so I think airlines will be allowed to certify under Privacy Shield. But that's what I understood.
Okay, we'll take one more question.
Thank you for this panel. My name is Paweł Szulewski, and I've got a question regarding Privacy Shield as such. My understanding is, and it was underlined during the panel, that Privacy Shield is, and the adequacy decision is based on some written statement and like obligation which US government and administration take on. Is there any discussion or, I don't know, political intent to discuss with US and to turn it into like real hard law, and real law, not only the administration, let's say, statements which may be changed?
Yes, really, that would be the, so to say, the ideal situation we're looking for, to rely on hard law rather than written commitments by the administration. It's not that easy because, of course, United States are federal states. Some states already are advanced with the adaptation legislation. We have a very quite high level of legislation. But yes, this is we feel even in 2016 an EDPS opinion said that we could only consider that this is a temporary solution, and in this way we were calling for, of course, hard law, having safeguards and principles in U.S. hard law. Yeah. But for now, it's not. We don't see it's moving this way.
So we're being told that the panel has run out of time to answer questions. We'll stick around if you have any additional questions. And in conclusion, we all live in a global world with a great deal of outsourcing and lots of data being transmitted over the internet every day. So now that the GDPR is going into effect, even if the Privacy Shield standards are a bit easier to meet, especially given the new Schrems decision that was just announced, it's important for companies to have a strong level of compliance, and in some ways the GDPR sets the playing field for the whole world and not simply the EU. So good luck with your compliance, and thank you very much for attending today, and we're happy to take any other questions that you have before everyone leaves the room. Thank you again, and thank you, Peter Schaaf.